Thank you all for being here. We will go back on the record with the screening here. Mr. Miller, if you'll come forward to the podium. Ladies and gentlemen, before us we have Mr. David Miller, who is an applicant for the Seat 2 position in the Second Circuit Court. Mr. Miller, if you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll look in front of you, you should have some documents there. If you'll review those, please.
Yes, sir.
Are those the personal data questionnaire and the sworn statement that you have submitted to the commission?
Yes, sir. They appear to be, they are unsigned.
Okay. Are there any updates or changes that need to be made to those?
Not that I'm aware of, sir.
Do you have any objection to making those documents a part of the record of your testimony here today?
I do not.
Ladies, got it? Okay. The Judicial Merit Selection Commission has thoroughly investigated your qualifications for the bench. Our inquiry has focused on 9 evaluative criteria and has included a ballot box survey, thorough study of your application materials, verification of your compliance with state ethics laws, a search of newspaper articles in which your name appears, a study of previous screenings, a check for economic conflicts of interest. We had received 4 affidavits filed in opposition to your election. My understanding is that 2 of the affiants are not here, and pursuant to our rules, those affidavits cannot be entered into the record. However, the 2 affiants that are here are witnesses in opposition to your election. And so before we proceed with the balance of the questioning, we're going to hear from them first. So if you'd like to take a seat there in the front row, we will call forward Mrs. Ford.
Yes, sir.
Thank you. And Ms. Ford, as you make your way to the podium, I have reviewed the complaints, and I want to, just as a preliminary note, recognize the gravity and the sensitivity of the issues involved in those allegations. And I want to emphasize here the purpose of the commission is to evaluate the constitutional and statutory qualifications of a candidate, in this instance, Mr. Miller. This is not a place where we can provide some relief or remedy to any case whatsoever. And so I would ask, while there's certainly a need for a factual basis and a foundation for understanding the complaint, we need to be mindful that the focus should be on the 9 evaluative criteria. And I just offer that as a cautionary note. So we're going to give you all the time you need to be heard. We want to make sure the commission has all that information so we can then incorporate that into our report to the General Assembly as per our charge. But just keep it between the left and right lateral limits, if you would, please, ma'am.
Yes, Mr. Chairman.
One more thing. If you would, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. Be happy to hear from you.
Thank you, Mr. Chairman. I know when a lawyer says that they're going to be brief, it's normally the opposite, but I promise I will be brief. My name is Sarah Ford. I'm a lawyer and advocate for crime victims, and I'm here before you to share my concerns and those of clients regarding David Miller and his candidacy for circuit court judge. I am not here to relitigate any case. I am here to express my viewpoint in an effort to make the candidacy of Mr. Miller more comprehensive for this body to consider. The majority of judges and those running for judges are excellent candidates. But it's important to note that I don't think most judges or lawyers have no complaints submitted because there are no complaints, but because people are apprehensive of the consequences of making those complaints known. No doubt Mr. Miller believes very differently from my opinion and those of clients who have also submitted affidavits for you all to read. And of course, this commission may consider some or all or part of the testimony that is submitted. It's difficult to be succinct in cases that have stemmed many years. However, one thing in all of the cases, in my experience with Mr. Miller, is this. Mr. Miller lacks sensitivity to victims and their positions and the laws that protect them. His action or inaction in cases left multiple victims and survivors feeling re-victimized and without faith in our system, which as a lawyer, I absolutely detest. Everyone should feel confident and secure that if they are a crime victim, their case will be investigated fully, that the matters will be prosecuted effectively, and they can count on justice to be done for defendants and victims. There are cases in which Mr. Miller was involved where victims' rights were not protected or complied with, even by his own admission. Cases in which victims were told investigations would be reopened and nothing ever happened other than to string victims along, making them believe that cases would be prosecuted, and ultimately they weren't. Situations where requests for information went unanswered for months.
Senator Sapp.
I really hate to interrupt, but it's almost as if we're talking about a broad spectrum. Now, I've read the complaint that was filed, and it seemed very specific in terms of the subject matter. As I'm trying to follow you, it appears as if your comments are directed to more than what's identified in the complaint. Am I reading you right in that?
Correct, Senator. I am speaking broadly about my experience as a former prosecutor and a victims' rights attorney with my experiences with Mr. Miller. The case specifically that I spoke of in my affidavit specifically was a case he prosecuted on the Bowen Turner case, but I also referenced several other cases as well. So I'm not speaking specifically on the Turner case, but more my broad perspective on that. I hope that answers your question. Thank you, sir. May I continue?
Yes, ma'am.
There were situations where Mr. Miller allowed defendants to travel places contrary to bond orders without giving victims the opportunity to be heard on that. And that's concerning for me as an attorney, that someone who has behaved in such a way is seeking a job as a circuit court judge. You know, South Carolina law requires that family court and circuit court judges protect the rights of victims as diligently as those of defendants. You know, my concerns extend to his disposition of cases, catering to certain defense attorneys, failing to fully prosecute cases in which multiple women were sexually assaulted, explaining to victims that he didn't want to make it look like he was, quote, going after a defendant who was accused of at least 3 sexual assaults, and not complying with laws in situations that would benefit defense attorneys. Our judiciary needs individuals who are exemplary in every way, ethically, intellectually, temperamentally. I do not believe, based on my experiences with Mr. Miller, that he has those necessary qualities. I do stand on the submission of Dr. Bess, Mr. Montgomery, and Mr. Stoller as further evidence of those concerns regarding Mr. Miller. And as such, I do encourage the commission to find Mr. Miller unqualified for the position of circuit court judge. Hope that was brief enough.
Yes, ma'am. Thank you. Any comments or questions from members of the commission? Seeing none, thank you for being here. Thank you for your testimony.
Thank you, Mr. Chairman.
Next, I'd like to call Mr. Stoller. Am I pronouncing that correctly, sir? Stoller? Okay. Thank you, sir. We'd be happy to hear from you. Oh, I forgot. I do need to put you on come on down. Apologies. If you would, sir, just raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. As I said, we'd be happy to hear from you.
Good afternoon. My name is Carl Stoller. I came to speak to you today as a parent of a victim, one Dallas Stoller, and also as a law enforcement officer in this state. In my capacity in law enforcement, I've had the privilege of dealing with many fine judges, solicitors, and even attorneys on the defense side. But I've never quite had the occasion to deal with someone quite like Mr. Miller. What I experienced as a parent of a victim was someone who I would bring his character into question after dealing with him, his demeanor, and his general lackadaisical attitude towards that case. And what I mean by that is I never met the man, okay? I talked to him one time on of us. And again, as a law enforcement officer, I've never experienced.
Thank you, sir. Do any members of the commission have any questions for Mr. Stoller? Senator Sapp.
And so I guess I would start off by asking you to accept our condolences.
Yes, sir.
Yeah, one of my mother's prayers was that she would be taken before any of her children, and it's just not a natural thing. And so, but I'm curious about some of the things that I read, and as I understand it, there was an understanding that there was going to be one type hearing when you all appeared, and as it turns out, it ended up being in a guilty plea. What I'm curious about is, at the time of the guilty plea, were there members of your family who would otherwise have been there if they had known that it was a guilty plea as opposed to a bond hearing? Sure, yeah, So for instance,
Family members there.
no, so for instance, let's assume for a second, there are three people who are really interested in this case, right? And then they understood that there was going to be a bond revocation hearing. These three people. And one of them said, well, I'm not going to go because it's just a bond revocation. It's not like it's a guilty plea, or it's not something that's dispositive of the entire case. It's just one procedural thing that's a part of the case. And so I was curious, and I couldn't glean from what I read as to whether or not there was or whether there wasn't some.
I would say generally that, honestly, Senator, that most everybody in my family did attend.
Okay.
We don't have a very big family, so
Yes, sir.
everybody did, and a lot of friends and whatnot in the community, which we were very appreciative of. But yes, that was advertised as a bond revocation hearing publicly,
Yeah.
and it turned out to be the acceptance of a plea deal.
Yeah. So let me be candid with you and tell you, as I read, what concerned me, but now I'm not as concerned on this particular issue as I was initially. Initially, I thought it may have been one of those situations where some people did not come because they didn't realize what was actually going to take place.
Yes, sir.
But it sounds like in this situation, at least fortunately from the standpoint of anybody who wanted to be there, who wanted to be heard, they would have been there.
Yes, sir.
Okay.
Yes, sir.
All right, that helps me.
Yeah, and we were allowed to give a victim's impact statement
Yes,
to
sir.
the judge at that hearing, which I think we all know that's a joke. The decision's already made before you're allowed to speak as a victim. That's a fact, okay? So it has about as much bearing on it as, excuse me, but flying to the moon, okay? So we were able to do that. So we were able to say some things that we needed to talk about, but at the end of the day, the decision was already made, and it was made well in advance. And to that point, I will add to this, that court order, that bond modification hearing in Lee County, I'm backing up a little bit. I think it was Judge McFadden, made an order that said that should a defendant violate the conditions of his bond in any shape or form, he is to be immediately taken into the custody. He lived in Orangeburg County by the Orangeburg County Sheriff's Office upon notification, okay? If he's observed, okay? So he was wearing a GPS monitor.
Yes, sir.
And we can wear out the rest of the day talking about GPS monitors.
So can I
okay?
interrupt one quick second?
Yes, sir.
Just to share this as a matter of information, because I sat on a subcommittee this past year when we passed
Yes,
the
sir.
bond reform bill.
Yes, sir.
And what we discovered was there were a number of instances where persons were on GPS monitoring, violated it, and nothing ever happened.
Nothing happened.
And so that's one of the things legislatively that we tried to tighten up on, because it's not good for anybody when that occurs. And so,
I appreciate that, because you're exactly right. As a matter of fact, probably 8-9 weeks ago, I arrested a guy with a GPS monitor on, not for the GPS monitor, but he was committing another crime while wearing one.
Yeah.
So that's still about how good that is, okay? But to my point, this defendant, Mr. Turner, was ordered to wear this GPS monitor, which he was wearing, documented 50 plus, there might have been 60 violations of bond. That paperwork showed up on this gentleman's desk, from my understanding, about a month before he ever put this ad in the paper about the bond revocation hearing, okay? Well, everything's up to interpretation, right? But I think it's pretty obvious the way the judge wrote that order. He said, if he's observed violating the conditions of this bond, he is to be taken into custody immediately. Not let's talk about it a little while, think about it a little bit, and then go get him. Let's not set up the bond revocation hearing. The order goes on further to say that it would be set after he is picked up, okay? That wasn't done. The argument Mr. Miller posed is, well, we didn't observe him doing that. Well, again, You got the printout that shows it. That's an observation, right? I'm seeing that. So to my point, and again, Senator, I appreciate your comments about the GPS, and I'm thankful that something's actually moving forward with it. But to my point, what's the point of GPS if that's not a tool for observation? We can't station a deputy outside that yard 24/7. It's impossible.
Promise you I get it.
So that's what I would say to that. But that's the response I got. So that, you know, it's just been a horrible experience with him. And, you know, hey, at one time he may have been an excellent prosecutor. He might have been right on target, but somewhere along the line he's lost his way. Okay? Too many years, maybe spoiled to it, soured to the system. I know in law enforcement you get that way because you don't feel like you're making any difference. Maybe that's the case. But all I can speak to is what we dealt with as a family.
Thank you, sir. I think Ms. Blackley has some questions or comments.
Yes, ma'am.
Hello, just wanted to extend my condolences.
Thank
to
you so
and
much.
family. And just to tell you, I can empathize. I'm a former victims advocate. I would like to still consider myself an advocate for all people in all ways. I do want to go back to a statement you made earlier in regards to Mr. Miller, when you said that he never reached out
Correct.
before that Zoom hearing. What
That's
did you,
correct.
what in what indications, in what way did he not reach out? Was it?
He never made any contact with us. You know, he never made a phone call. I think he talked to my daughter one time. I think. I can't swear to that. She was 17 when this happened, so obviously our parents are still involved when the offense occurred. But he never bothered to even come and introduce himself as the person prosecuting the case for the state. It was literally in the hearings I did sit on, especially one in Lee County, when the defense attorney, Mr. Hutto, would propose something. I've never, again, being in law enforcement and sitting in a courtroom many times, I've never seen a prosecutor that didn't at least have some exception to what the defense was offering up in their words. And it was all right. No, that's good. I'm good with that.
But-
Always.
But for point of clarification.
Yes, ma'am.
Was it, but you were notified for all court proceedings or your attorney? Well, you probably.
Sometimes it was, if it hadn't have been for Ms. Ford being involved, we wouldn't have known about them. No, ma'am. Because the solicitor's office, the Second Judicial Circuit Solicitor's office, not just Mr. Miller, they didn't talk to us about a thing.
Well, you never, did you not receive a victim's impact statement form from the victim's advocate?
I do
within
not
the solicitor's
recall
office?
getting anything from the solicitor's office, ma'am. We got some information from SLED, and that was about the extent of it. But Ms. Ford was the one that was able to let us know when something was coming up.
Thank you.
Yes, ma'am.
Senator Rankin.
Yes, sir.
Stoller, Luke Rankin.
sir.
Sorry to meet you under these circumstances. I am a father and just cannot imagine all of this. And I just want to ask a couple of questions.
Yes, sir.
Again, embrace the condolences that we have for you, that any father of a child has for your loss and
Yes, sir.
ever being in this situation in the first place. I've read your affidavit, and I've got the transcript here where
Yes, sir.
you without any prodding, because you know how to speak in public as well as you've done
Yes,
here
sir.
today, speak freely to Judge Dennis
Yes,
about
sir.
your position. I want to ask one question, though, because it's a unique thing to me. You reference in your affidavit that Sarah Ford was your daughter's legal counsel.
Correct.
Did y'all retain her?
Yes.
And
Yeah.
And
She came to us through SC Van.
and so is that a paid position
No, sir.
or just a rights acknowledged?
She is a victim's rights attorney, so
Okay,
she was
and
there
she
to
was-
represent the victims.
And
Yes,
she
sir.
spoke first at the hearing, I've read that, and then she introduced you and others before Judge Dennis, correct?
That's correct.
Okay. Horry County, I think all counties, all districts rather, have the victim's representative within the solicitor's office that is separate and distinct from the assigned solicitor.
Right.
And who was that, who served that role for?
I don't recall ever meeting anybody in that role with the solicitor's office. I may be incorrect, but I don't remember anybody coming to me saying that they were the victim's advocate for the solicitor's office. No, sir.
And this case arose from an event that took place in Orangeburg, correct?
In Bamberg County. My
Bamberg.
daughter was assaulted in Bamberg County.
And who is the solicitor for Bamberg?
Bill Weeks.
Okay. And is that the assistant solicitor or the head of?
No, David Miller's the deputy solicitor, and his boss is Bill Weeks. He is the solicitor.
Okay. And that, and this case was transferred out because of what? What was the conflict that?
It was conflict, the Chloe Best case, the third incident, it was conflicted out of Orangeburg because David Pascoe is the solicitor in Orangeburg County, First Judicial Circuit. The defendant's father, Walt Turner, was an investigator for the First Judicial Circuit Solicitor's Office.
And who is the first solicitor?
David Pascoe.
So David Pascoe's
Investigator,
Investigator is the
son
father.
was the defendant.
the father of the defendant.
Correct. Yeah, Mr. Turner, Walt Turner is his father, the investigator. And so David Pascoe conflicted out. Second Judicial Circuit Solicitor Office was already working on Dallas's case in Bamberg County. And because of that, it's my understanding that Pascoe passed it over to them because they were already working on the case involving the same defendant. And he conflicted himself out because of his employees, the defendant being his employee's son.
Who is the investigator?
Walt Turner, who is Bowen Turner's father,
David Pascoe.
for David Pascoe, for Solicitor Pascoe, yes, sir.
And so I don't do criminal law at all. These folks that are wishing that I would hush will attest to that. But
It's okay.
Again, and I've had who are victim. I become a contact on behalf of. I've got a trustee that I serve as a trustee of an infirmed person who was victimized by a crime. But and again, it may just be one county or another. Some are more astute, but I literally got more contact from not the solicitor assigned to prosecute this case, but from a couple of folks in an administrative role. And not that speaks to the relationship or the interaction that you've complained about today, but are you saying that that was really not present in this case, either from Orangeburg or from Lee County or?
Absolutely. I was never contacted by anybody with either victims assistance, victims advocates with the solicitor's office. We did, like I said, a SLED victims advocate did reach out to us early on. But that was while SLED was doing the investigation. I had no contact with now maybe my wife did, and I'm not familiar with that, but not me. But I did think it would have been appropriate too for Mr. Miller to have at least introduced himself to us as being the prosecutor, because he was not the original one on the case.
And your role in law enforcement is what?
Sheriff's deputy in Orangeburg County Sheriff's Office. I'm a sergeant there.
In Orangeburg?
Yes, sir.
Okay. And so you know folks in Orangeburg well, I'm sure.
Yes, sir.
There's a
And I'm
victim.
born and raised in Bamberg County. My father was the agent in charge of probation parole in Bamberg County for many years. I knew Mr. Weeks when he was just starting out. I was Judge Peoples' jury boy when I was 11, 12 years old. So, yes, sir, I've been around for a while, 54.
And not that their voice counts, but in terms of how it's done in Orangeburg, is it done differently in terms of that victims outreach?
Yes,
than-
sir. Our sheriff's office has their own victims advocates office. Amy Rickenberger is our director. She is on it. You know, when we take calls for service, that's the first information we give to a person who is a victim of a crime in Orangeburg County. We have a list that we work by. They stay in contact, and I've never had one complaint out of Pasco's office that their victim's advocate has not reached out and followed up and coordinated with ours. Never, not once.
And again, maybe of no value, but surely you're not afraid to reach out and talk to the folks you interact with all the time. Did you ever tell your solicitors in Orangeburg?
I did.
And
I
what-
did have a meeting with David Pasco. I did.
And what did he?
He thought it was
suggest?
appalling. Yep.
Who was, yeah, what
There was no contact. He thought that was appalling. Yeah.
so he would know his brother or sister in a different solicitor's, in Lee County, I guess, Weeks. Did you
You
ever
know,
speak?
Aiken, their headquarters in Aiken County. That's the
Forgive
seat
me.
of the Second Judicial Circuit, yeah.
So did you ask him to reach out to?
I've said any information. Our former chief deputy with the sheriff's office, Kenny Kinsey, Dr. Kenny Kinsey, who was, everybody knows about in the Murdaugh trial. Yeah, he tried to, our sheriff, everybody, we couldn't get any, I got no information, none.
Did Pasco get information for you from his brother,
If he got anything, he told me, I recall him meeting with me one time and saying that, that, and this was kind of after the fact. This was after the case had been disposed of, and there was talk of reopening Dallas's case. He had reached out to me, Bill Weeks, said, yeah, he said, we're going to take a second look at it, and we're going to look into it a little bit. Mr. Miller won't be involved this time. And that was one of the last things that Mr. Pasco relayed to me, that they had some communication with them, and that's been well over a year ago.
So the first solicitor in, again, Solicitor Weeks' office, who was that?
Who's the
Who was
solicitor?
the first one assigned this once it was transferred?
When Dallas's assault occurred, there was another, and I can never remember this young man's name. I think his first name was Michael. He was the prosecutor assigned to Dallas's case. And he got out rather quickly. I think he had some kind of conflict, or honestly, what I was told is he was physically intimidated by the defense attorney, Mr. Charlie Williams. And he was scared of his size and stature. That's what I was told. And then the next thing I know, I get Mr. Miller. We find out that Mr. Miller's our guy handling the case. And and that's what I would stress at that point. The part about the first guy, that's neither here nor there, but at that point, if he's the new guy in town, it just like if I was investigating a crime and I was new to the case, I would certainly introduce myself to the victims and saying, hey, I'm here working for you. He didn't do that.
Mr. Saffron. Before you get going, let me just interject here. I appreciate the issues we have before us, but I want to remind my fellow commissioners that our task is to evaluate the candidate as to the evaluative criteria. I know there are moments where our curiosities bring us into details of the case, but insofar as we do that, it needs to be directly related to our mission and scope. Thank
I
you.
would think that some of the questions they're asking are speaking
Yes,
to the
sir,
character.
absolutely.
to
I
his
just, as
character.
we get into details that are more tangential, we need to
Correct.
just be mindful of that.
Thank you, Mr. Chairman. I hate having to go through this with you.
Yes, sir.
I mean, it's a trauma every time you do it.
Yes, sir.
Okay? And I hate it for you.
Yes, sir.
I'm just curious about a couple of things. And again, my whole goal here is to just get a fair understanding of everything.
Yes, sir.
And with the understanding that, as you know, because you're in law enforcement,
Mm-hmm.
when we come to something like this, we're not a super jury. We don't basically go back and try to figure out what should have been.
Right.
What didn't. It's not our job to do that, but it is our job to kind of at least understand, okay?
Yes, sir.
What I'm hearing from you is a couple things, but let me just ask one quick question.
Mm-hmm.
Some point while your daughter was still with us,
Yes, sir.
y'all got Miss Ford involved. Is that fair? I mean, she was still alive.
They actually, Ms. Ford actually reached out to
Right,
us.
so, I mean, she got involved, and as you say, somehow y'all more or less connected, she was acting as your attorney from that point forward.
Correct.
Okay.
Well, Dallas's, yes, sir.
Dallas, but then even after that, I believe, even after that untimely thing,
Yes, sir.
y'all were still she was reaching out to you and still kind of representing your interests.
That is correct, yes,
Okay,
sir.
Okay. Now, you talk about that you didn't hear anything from Mr. Miller during
Mm-hmm.
that time frame, him reaching out personally to you, okay?
Mm-hmm.
Is there any possibility that Ms. Ford had told him not to?
Not that I'm aware of.
And if that was true, though, that at least might.
Mm-hmm. That might speak
that
to
might
it,
be
but
consistent.
I don't think that was the case, no,
And
sir. Mm-hmm.
I'm just asking, you, to your knowledge, that wasn't the case.
Because Mr. Sanford, because she was she was Dallas's attorney, he would be under no privilege that he couldn't speak to me separately.
No,
Okay.
and I get that, but I think sometimes people may assume more.
Right,
At least if in fact he was told, don't go through to them, you go through me.
Right.
That at least is a possible explanation, if and in fact it happened. Is that
Right.
fair? Let me ask you also, what I'm hearing is this, you know, you deal with these issues as far as the law enforcement stuff every day. And what I'm hearing from you is at least your experience is the interaction between solicitor and victims is different based on what your normal experience is. And I mean, do you, as an investigating officer or arresting officer, do you stay involved from a victim standpoint once, you know, so you stay in that part of the case
100%
the whole way?
to the end.
So you'd be talking to your liaison within the department. You'd be talking to whoever the person is at the solicitor's office.
Yes, sir.
Is it fair to say, because I mean, have you spent your whole time as far as law enforcement with the Orangeburg Sheriff's
Yes,
Department?
sir.
Is it, I mean, I represent a lot of law enforcement
Yes, sir.
people in what I do, but I see from department to department, things aren't uniform. That one place may have something crackerjack, and another place you might look at and say, they're not even in the same room.
Oh,
I mean, we all understand that is a
dispute that.
reality. And
yes, sir.
what I'm also hearing is this. You, on one hand, as a law enforcement officer, understand how the legal system works. And I think I heard you say, I understand about having to try to prosecute without a victim. You've got that part. What I'm hearing, though, is that there wasn't at least maybe the inclusion in the process to kind of maybe let you know as things were going along, this is what we're hitting as an obstacle, this is a problem we got, and really kind of reaching out to you from the human side as opposed to maybe just.
Well, I would say human and professional. You
Okay.
know, I would argue that that would be a human element one, but primarily a professional element. That's what my stance would be. I would think that he would need to talk to us
I
about
mean, with the
that.
professional side, again, the lack of communication.
Yeah, and just a general, again, I don't know the word for it, a lackadaisical attitude
And I
towards
think-
the whole thing. It was very passive, just push it off. And he was irritated. I mean, just like I said in the Zoom meeting, anything you said and questioned him, he was immediately irritated by that. And I find that very unprofessional.
And what I'm hearing is at least where most of that comes from is at least in that one interaction on the Zoom, all those things kind of came to you as far as don't care. This is
Right.
ju- We're just a number.
Right.
Okay.
And you're not gonna waste my time.
Well, and
I don't think I would have ever said that I've never said that to a victim. Never once. Matter of fact, I think the sheriff would take my badge if I did that.
thank you.
Okay?
Thank you. Let me just say, Mr. Stoller, if you don't want to take any more questions, you don't have to.
I'm fine.
Okay.
Shoot.
At this point, I just recognize Mr. Strom. He indicated he had a question, and Senator Sapp, I saw you as well.
Yeah. Thank you, Senator. Thank you, Mr. Chairman. Mr. Dawes, I join everybody, and I've got two daughters. I can't imagine.
Yes, sir.
I hate it. I wrote down three words: temperament, procedure. What I mean by that is constitutional, and outcome. I heard you on the temperament. I heard everything you said about that.
Right.
Constitutionally, you understand what we're talking about, victims' rights. You deal with that. Is there any issues with that in this case from your?
Well, Mr. Strong, I think, if I can speak candidly, I think that a lot of times victims' rights are routinely violated, honestly. And what I'm speaking to is the fact that you're allowed to give a victim's impact statement after a judgment has been rendered. That's not right. What effect does that have if it's after the fact? The decision's already been made. All you're doing is just telling a little story, how things went out. So, I consider that just a waste of time, honestly. And I think that to a degree, because I'm not aware of him talking to my daughter but one time, that he or his clerk or his aide, whatever the heck you want to call it, somebody should have been, because she was a victim.
Right.
She was the one. He should have been at least communicating with her. You can push me to the side. I'm fine with that. I can deal with that. But deal with her, because that's your job, okay? And so I think that honestly, I can't sit here and defend that victims' rights are always protected. I can't do that, because I'd be being dishonest.
But I guess, and I get what you're saying, they dropped the ball because they didn't communicate the way they should. But it sounds like that after y'all's case came about, you got notice about the hearings, because you went to all the hearings.
I went to a bond hearing in Bamberg County.
Okay, you went to that, and then you went to what you thought was gonna be a bond revocation.
We actually had a couple bond hearings, a bond mod in Lee County, one in Bamberg, and then because he got in more trouble and he had to be remanded to the Department of Juvenile Justice for a period of time. And one of those was announced so late, there was no way you could get to it,
Who was communicating with you about those hearings?
I think Sarah got us some information on those, if I make no mistake, when she got involved. But I know for a fact Lee County and ultimately, which it was advertised in the T&D, the local paper in Orangeburg, that we were going to have a bond revocation hearing. And I did that because that's the approach you had, is 6 guns out,
So the Lee County hearing, what was that?
That was a bond modification hearing. Mr. Turner was having to live with his grandmother. He was not allowed, as part of the condition of bond, to live with his parents. And they asked for him, Senator Hutto asked for him to be able to go back to his parents' care. And unfortunately, that made granted with no opposition by this gentleman behind me, that it was okay, it's good. And what that led up to was the assault of Chloe Bess, 45 days later.
Did y'all get notice of that hearing? So the
I
bond.
didn't get an email or anything like that. I
bond-
think Sarah was the one that let me know that it was coming up.
Okay. That it was coming up, or that it
It was
happened?
about to happen.
And,
So we stopped everything we were doing and went, because I made a statement there.
okay, so you went to that one? Okay. Now, I think you said there was one that it was such short notice you didn't get to
Correct.
it. Well, tell me about that one.
I think that was in Bamberg County. And honestly, I believe that might have been the initial bond hearing, the very first one on Dallas's case. Because the one I actually went to, there was another request for modification to remove the GPS monitor.
So y'all
Because
didn't.
he was initially on the GPS monitor in Bamberg County.
So you didn't, you're in this was in
Bamberg County.
Bamberg. You didn't get notice of the original bond hearing in Bamberg County? Okay, but
I don't recall ever.
that would have been set in magistrate's court.
That's right.
And typically, the solicitor's not involved unless.
No, and Miller wasn't even the solicitor at that point.
Okay. Okay,
Now, let me make that perfectly clear. He was not involved out the gate.
okay. So where did he get involved?
I think that came in after, I'm at a little bit of a loss there. I think that came in at sometime between the bond hearing, the bond modification hearing request in Bamberg County to remove the GPS monitor.
Right.
And then somewhere in the interim between that and the Lee County thing, because I definitely know I saw him in Lee County. I do not recall seeing him in the courthouse in Bamberg, but honestly, When that one happened, my father had just died a couple days before, and I wasn't really paying a lot of attention.
All right, and then, were there any other hearings that y'all didn't get notice of or got real short notice of?
Those were the only ones that I remember them ever having.
Them having,
Yes, sir.
okay.
Yes, sir.
All right, and then when it came down to the plea negotiations and what worked out when you thought it was going to be a bond revocation and it turned into a plea hearing, tell me some details on that.
Say that again.
All right.
What do you want me to?
I want to know, you said you had a Zoom call?
Yeah.
Okay, and he was less than kind and polite, and how far in advance of that was that before the,
I want to say it was the day before the hearing. It was a very short period of
and
time.
y'all thought during that Zoom call, it was going to be a bond revocation and not the plea?
That was how it was advertised. Yes, sir.
All right, when
But
did
I kind of knew it wasn't going to be that way. I already kind of figured it out.
you kind of figured out?
Yes, sir.
Okay.
Experience
But
allowed me to figure
everybody
that
else
out.
on that call would have thought that it was a bond
Yeah,
revocation.
that was a bond revocation hearing coming up. Like I said, again, it was advertised publicly in the local paper
All right, so
as such.
y'all show up for what you think is a bond revocation, at least everybody else did. You had in the back of your mind with your experience that this thing was going to get changed.
Once I knew those GPS readings came out and nothing happened, I said, here we go.
All right,
That
so-
compels you to get something done.
All right, so when did you find out what the offer was on the plea?
At the courtroom that day,
That morning?
that morning.
Okay.
Yes, sir.
All right, and tell me about that conversation. Was everybody involved? Who all was?
We were sitting there in open court. So, yes, sir, everybody was involved.
Did he come tell you ahead of time or?
No, sir.
So,
I'm telling you, I've never spoken to that gentleman in person.
so the first time you heard that the case was being pled to an assault case.
Assault battery one.
Was on the record?
Yes, sir.
So they were telling the judge,
They were presenting the information, sir, right there when it was being done. That was the first I'd heard of it. Yes, sir. Even though, like I said, my intuition and instinct told me I knew that something was going on.
you know, and I've been in the solicitor's office, I've been on the other side.
Yes, sir.
All right, when you do that, you prepare your victims to talk. So at some point, somebody had to have a conversation with you to say, do you want to come up and speak?
Ms. Ford said
Okay.
we're allowed to give a victim's impact statement
Okay,
after the fact.
okay. Were you opposing the plea going forward at that time?
Absolutely.
Why?
Because I thought it was ridiculous
You thought what part of it was ridiculous?
to take a young man who has the first victim, known victim, remains anonymous, okay? The second being my daughter, who is now deceased, and the third being Miss Chloe Bess. He had a pattern, Mr. Strom, of reoffending while out on bond. No regard for the law whatsoever. So I said, the reality of it is, there was a time, let me back up. When this thing first happened to my daughter, when Bowen was 16 years old, listen, my daughter never wanted that boy to go to jail. Because you know what? They were friends. They went to Orangeburg Preparatory School together, okay? She knew he had an issue. You find out about the history of this kind of stuff when something happens, okay? You find out from SLED that something had happened prior to your child, okay? You got to understand, my daughter, and I know everybody's going to brag on the daughter just like you would yours, right? But she was an exceptional person. And she had one of the most forgiving personalities and hearts of anybody I've ever met in my life. And she did not want Bowen to go to jail. She wanted her friend to get help because she knew he needed it. And had that been listened to, maybe things would have turned out a lot different for everybody, right?
Been listened to by who? And what?
By all parties involved, the solicitor's office, the defense attorneys, et cetera. I mean, it just fell on deaf ears, But at the end of the day, to speak to your question about his sentence, I did not feel like it was appropriate to sentence him under the YOA for assault and battery first degree with no sex offender registry. Honestly, I don't even know why the word sex offender registry came up in the conversation for an assault and battery 1 charge, because generally that's not of a sexual element. Would you agree? All right, so obviously somewhere along the line, somebody's admitted to saying, hey, there's something going on. We're accepting the fact that there's a sexual element to it. So why wasn't it pled to maybe criminal sexual conduct in the 3rd degree or 2nd degree or something? Why did it go all the way to a and B1? I don't understand that.
I got it.
But again,
So-
I'm not a lawyer.
Right, so, but your complaint there is that you didn't like the plea negotiations, and you just learned about them that day.
That day.
And the victims didn't know that there was going to be a plea down to an aggravated assault or assault 1 until you heard it on the record?
That's when I heard it. And I'm going to have to assume that's when they heard it too. I cannot honestly speak to what they heard or didn't hear, but that was me.
Okay, so that's the outcome piece that I was talking about. But procedurally, I think we've covered all that. It sounds to me like the only real substantive issue procedurally is this plea, this bond hearing turning into a plea without victims having adequate notice. That's the one thing that, because you were at the bond hearings, is that right? Yeah. Okay.
Yeah.
Is there anything else that I didn't ask you about? All right, thank you.
Your stuff, so.
Yeah.
Thank you, Mr. Stoller. I appreciate you answering all these questions. You're
Yes, sir.
uniquely positioned to know all of these sorts of details as we try to evaluate everything. I think Senator Sabb had a question, to recognize him at this time.
And as it turns out, it really follows up on Mr. Strom's questions. When I looked at the transcript and I looked at what was placed on the record, one thing I did not see, and so I want you to help me with this one. Oftentimes when there's a plea negotiation, actually every time, it's incumbent upon the parties, actually both the solicitor and the defendant, to put the entire plea agreement on the record. One of the things I did not hear is that he is pleading to, is that the defendant has 3 charges pending, and that as a part of this plea negotiation, we're going to plea bargain this case from this charge to this charge, and we're going to dismiss 2 other cases as a part of the plea negotiations. I never saw that in the record. And so my question is, what is your understanding? Is your understanding that the defendant was pleading to the lesser charge, and in response to that, the state would be dismissing 2 additional counts, or were they all handled separate and independent from each other?
Yes, sir. The first case was never charged.
Yes, sir.
Okay. Dallas's case, he told us on the Zoom call that he was moving to dismiss. I'm assuming that decision was finalized by Judge Dennis in the courthouse in Orangeburg the morning of the so-called bond revocation hearing. I'll have to say that. But the best case, the Cloy Best case, that was the assault pled down to assault and battery 1, that's if I'm understanding you right, that you just got, it may not show up in the record or whatever, because I guess the first one wasn't charged. The second one, being Dallas's case, I was assuming was already dismissed. So I don't know why. I can't really speak to why it wouldn't show up, but
I just didn't see it in the record where
Yes, sir.
it was being conditioned
Right.
upon it.
Right.
And when I heard you say that there were some discussions about looking at the case again, that sort of confirmed in my mind that the dismissal was not a part of the plea bargaining as it
That's-
relates to
that's
the best
right, I
case.
would
So they
say
were
I
really
would agree.
separate and
Gentlemen,
independent
let
from
me
each other.
interrupt you there. I'm so sorry, but I've gotten enough side eyes from the court reporter. We got to go one at a time when we talk back.
I apologize. Thank you, Mr. Chairman.
Yes, sir. Sorry to interrupt you.
That's okay. Neither one of us were talking over each other. We were just kind of talking to each other, but sorry about that, Madam Reporter. But I think you and I are on one accord that they were really separate and independent from each other. Right?
Correct.
Okay.
Yes, sir.
Thank you, Mr. Chairman.
Thank you, Senator. I certainly meant no disrespect. Representative Rutherford?
Thank you. And again, let me join my colleagues in saying how sorry I am that you have to relive this.
Yes, sir.
As it relates to the bond motion, that hearing was held in Lee County, is that because he had?
Yeah, the bond modification, the second bond modification hearing, yeah.
You're referring to the second bond
Yeah,
modification?
because his bond was modified once before in Bamberg County.
Right. But the final, I guess, order of bond would be the second bond modification, just so we're.
To my understanding, yes, sir.
And when that bond modification hearing was held, it was your understanding that Mr. Miller objected to him getting a bond, correct?
In Lee County?
Yes, sir.
No, I don't remember him objecting to that.
But it says says in the order that the state was represented at the hearing by Second Circuit Deputy Solicitor David Miller, who opposed the request for bond.
I don't remember that at all.
Okay.
I'm not saying it's a lie, I just don't remember
Right,
that.
well, yes, sir, and it also, and maybe I didn't read far enough down, it says, the victim's family members were present at the hearing and were represented by Sarah Ford. And so I guess if she was representing you all, maybe she would have been the one to communicate to you all that he objected or didn't.
I'm gonna look back at her and defer, because I don't recall him ever objecting.
Oh, let me stop it right there. We got to do it one at a time on the microphone so we have it all on the record. All this is recorded and such. So if you
then
know, you can say you know. If you don't know, you can say you don't know. If you don't recall, you don't recall.
I don't recall.
I want to be very mindful of it because I recognize the natural speech patterns of, quick responses back and forth. So, but because the boss lady there has made clear that we've got to be more deliberate about
Okay.
question, pause, answer, pause, question. So, Mr. Rutherford.
Thank you. And this order states, and I assume this is the one that you were referring to, that he's to be on home detention and that any and all violations shall be reported to the Second Circuit Solicitor's Office or the Orangeburg County Sheriff's Office within 24 hours of the violation. And it is directed at the Orangeburg County Sheriff's Office, Orangeburg Magistrates to them out. Was he in jail in Orangeburg at the time?
When the bond modification, no.
Okay, he was in jail in Lee County, or he was out on bond?
He was out on bond.
Okay.
Yeah, he was just having to live with his grandmother at the time. They wanted him to be able to return back home and live with them.
And so, before the plea, when he was out on GPS monitoring, he was living in what county?
Orangeburg County.
He was living in Orangeburg? Okay. And the observations of his violations of the bond were made by whom?
Okay, this is where I'm gonna go back to the GPS thing, okay? It is my understanding that we're the GPS monitor. I think, you can correct me if I'm wrong, but I think in this situation, a bail bondsman is the one that handles this while they're out on bond. They're supposed to be monitoring his activities. If they see him violate or go outside of his perimeters, they're supposed to notify law enforcement that he is outside of that, okay? That did not happen. The only reason that those noted violations came to light is because the mother of Chloe Best, Miss Carol Best, had been hearing that Bowen had been seen in multiple places that he was not supposed to be. She pressed the issue. And finally, the bonding company released the data for the GPS printouts, it's my understanding sent them to the solicitor's office, okay? I know they didn't come to the sheriff's office. Sent them to the solicitor's office. And that is where I guess we all differ in our opinion on what observation is, but that GPS printout is supposed to be the paperwork you would need to be able to observe to say that, okay, he has been operating outside of his limits. And per the judge's order, if you read it, Mr. Rutherford, he was, once that's discovered, he's to be immediately, not later, but immediately placed into custody and held in the Orangeburg County Detention Center until a bond revocation here can be set.
Right, I saw that. But you never were privy to, you never had access to exactly what the violations were, other than
It was
there
all,
the GPS.
it was printed on the news.
Right on the news.
Yeah, it was all over the news.
But in terms of you seeing that, nobody reported that they saw him out after 7 PM. Is that fair to say, according to your?
Not to my knowledge.
Right. Because the problem is that if you look at it, it says there are places that he can go between 7 AM and 7 PM. And so using the GPS coordinates, you'd have to figure out that he was not at some place that
Yeah,
he was
those
allowed to go.
printouts will show you where he was.
Right.
They will tell you where he was. He was in Georgia.
If you would, sir, two things. One, we got to remind ourselves to not talk to each other at the same time.
Okay.
Also, I would remind everyone we are focused on Mr. Miller as a candidate. And again, there's a lot happening here. Anytime you have multiple jurisdictions involved, trying to unwind and understand everything is not necessarily self-evident. So I understand the need for a lot of questioning, but let's stay focused on the evaluation of Mr. Miller as a candidate for judicial office.
Right, and so Mr. Miller, nor you, best of your recollection, nobody said we saw him out after 7 PM. Is that right?
Nobody physically saw him out.
Yeah. In terms of observation, nobody said that they observed him out after 7 PM.
Right. And I guess that's your definition of observation, is actually seeing the person. Mine differs in that, but that's okay.
Is there another word for observation
If I had a paper and it had those printouts and it said he was in Georgia on December 24th, whatever year, that's certainly not on Jackson Boulevard in Orangeburg County. Okay, so that, to me, Mr. Rutherford, again, that's an argument, I guess, that we all can have later on. But to me, that's an observation.
But was there an observation of him that Mr. Miller ignored, that he was out after 7 PM? Or did the coordinates put him out after 7 PM?
Coordinates put him out after
After
those
7
timeframes, yeah.
Okay.
So that's why I argue that there's an observation there, yeah. He was, to speak to what you were saying a minute ago, about he was allowed certain areas to counsel and to see his attorney, to different, I don't even think he go to church, honestly. I don't think that was part of it either. But I tell you where he was. The night after my daughter was buried at 11-something o'clock, he was at that cemetery, at the cemetery she was buried in.
And so when you're saying the Orangeburg County Sheriff's Office did not have notice, and that's why they didn't do anything about it?
They didn't give us that sheet.
All right, thank you, gentlemen. I appreciate that line of questioning, but I think we've exhausted that inquiry. So again, Mr. Stoller, as you've heard from all colleagues, extend my sympathies, all of our sympathies for the position you're in. Also, our gratitude for your willingness to take questions so
sir.
thoroughly. I think it's been immensely helpful, at least for me, probably assuredly to the other members of the commission, as we try to understand that and contextualize it. So I thank you for being here today. Thank you for your patience in helping us to understand the complaint as fully as we can. Also, I would be remiss if I didn't thank you for your service to the state as a law enforcement officer. I think most of us served at some point in the solicitor's office ourselves and have a very keen understanding of what goes on and the sacrifices made. So
Yes, sir.
certainly appreciate
Well,
that.
I appreciate that sentiment, and I will add to this, it is, as a law enforcement officer, it is and I don't, I know it's, a lot of people gonna take this as a smite, but it would be helpful if we had a court to back this up when we turn cases into.
Yes, sir. Thank you. Thank you again for being here and for your service.
Thank you.
So let me just note for the record that we will have entered the complaint of Mr. Stoller and Ms. Ford into the record. And at this point, we would also call forward Mr. Miller. Representative Jordan would like us all to take a break, so at his request, we will stand at ease for a few minutes. Thank you. Don't go far. Thank you, ladies and gentlemen. We are back on the record and will proceed with the screening of Mr. David Miller, a candidate for seat 2, Second Judicial Circuit Court. Mr. Miller, you have heard the testimony from the complainants here. Let me just ask you first, do you have any objection to entering your response to the written response to the complaint that you submitted to the commission? Do you have any problem with entering that on the record?
I do not, sir, and that would be the sum of my response to the complaint, subject to any questions that the committee might have.
Okay, we will go ahead and enter that onto the record then. It's on the laptops? All right, as well. Okay. I appreciate that. Are there any questions or comments for Mr. Miller with respect to the concerns articulated by the complainants from members of the commission? Senator Rankin.
Mr. Miller, Luke Rankin, nice to see you here. Again, I'm, very difficult situation for everyone involved here. I just want not to effectively tease out your responses, but there's some press here, or Fitz News. There may be other members of the press here. Obviously, you've got folks that have made statements that you've seen in writing, and you don't object to the written response that you've made. My invitation to you is not to read this, but as best you can, because this won't be published, your response will not be included in any record until and if there's a decision by this commission, which might not happen until December, January.
Yes, sir.
So again, not to offer you a lob of a pitch, because I'm not doing that, but I would suggest to you that if you would like to say something in response generally to the complaints that have been made against you, that if you would like, speak to that today.
Senator, I thank you, and I'll keep it very brief. The first time that I ever met Ms. Ford was actually into the process, as Mr. Stoller indicated. And when I spoke with her, she informed me that she represented Dallas Stoller and her family, and she represented Chloe Bess and her family. And Senator, as you are aware, under our rules, victims are defined as, in the case of minor children, also their parents. So the Stollers, the whole Stoller family, father, mother, and Dallas Stoller were victims in the case. When Ms. Ford told me that she was representing them, I told everyone from our office, we cannot talk to these victims except through Ms. Ford. All of our communications with Ms. Ford were to her to set up every meeting, every discussion, every Zoom call, every hearing. Every single bit of communication we had was to Ms. Ford. It was never directly to the victims. Even when, as Mr. Stoller indicated, I spoke to his daughter, which was in 2019, going into the start of COVID, because we actually got the Zoom call set up so that we could do that. Ms. Ford was there for that. She was on every single call. And so I realized, particularly from listening to Mr. Stoller's testimony here today, I had an expectation that what I told and what my staff told Ms. Ford was going to be relayed to the victims, her clients. And it's very clear that was not done. And I apologize for that. I did not ever address that with her because I didn't think that it was something that needed to be addressed. I made the assumption that I shouldn't have made, that what we talked about was being conveyed to the victims and the victims' families in the case. So I would first say that. And then just for the sake of clarity, so that, because there was a lot of questioning back and forth about it, Bowen Turner was accused in Bamberg County of a crime. That is a county over which I was responsible as the prosecutor. He bonded out. There were conditions on his bond. His attorneys came back and his attorneys asked for the electronic monitoring device that he was supposed to wear as a condition of bond to be removed. I was not the prosecutor in the case at that time. It was Michael Emmer. Mr. Emmer is another attorney that was in our office. The judge who heard that motion to have the ankle monitor removed the ankle monitor. 41 days later, Bowen Turner got charged in Orangeburg County. That's not one of our counties in the Second Circuit. It immediately got conflicted to our office. Michael Emmer went to Orangeburg for the bond hearing, and the judge for the bond hearing said that Bowen Turner was to stay in jail without bond or stay incarcerated without bond, but he was only 16. So he went to DJJ. At some point, Senator Hutto made a motion for a bond in front of Judge Casey Manning. That bond hearing was held, and ultimately Judge Manning said, I'm not going to grant a bond right now. Y'all, I'm dismissing it without prejudice, or denying it without prejudice, is I believe the way he put it. All of that was Michael Emmer leading up to that. The first time I ever became involved in the case was a bond reconsideration hearing in Dorchester County. And why are we bouncing around all these places? All of the circuit court judges in the First Circuit had recused themselves. So we found out that Judge McFadden was going to be in Dorchester County on the day before Bowen Turner's birthday. And that, or maybe it was the day of his birthday, I don't recall which one. But that was what Senator Hutto was arguing was the change in circumstance. I've got a 16-year-old who's being held in DJJ, and today he's going to go to the big boy jail at the Orangeburg Calhoun Detention Center. And so we went to Dorchester. Everybody did. We notified everyone, or well, we notified everyone for that. And when we got there, that's when I met Sarah Ford. And we vehemently argued against him getting a bond. We argued he should not have any bond because he was out on bond for a prior violent offense whenever he got this charge. Judge McFadden granted a bond with a number of conditions, including a condition at our request, after talking with the families, that the defendant had to stay at his grandmother's house because his parents' house was physically close to Chloe Bess's house, the Orangeburg victim. And so that was how it was left. This provision that keeps being talked about if the defendant is observed violating any term or condition of this order, I wrote that. I wrote this order. I wrote it for Judge McFadden in the Dorchester County Courthouse, and Judge McFadden penned his changes that he wanted on the order before he signed it, which you can notice on the last page. But the significance was when we left the courthouse that day, everybody kind of knew where we were and what was going on. And subsequently, somehow, and I don't know how, but somehow the defense became aware of the fact that Miss Bess had moved. She had moved to Florida. And so they made a request. Can he please be allowed to move from his grandmother's house to his parents' house to be on the electronic monitor? Still on the electronic monitor, still all the same conditions. We just want him to move essentially 3 miles. And that is the hearing that Mr. Stoller keeps referring to as the Lee County hearing. That was the Lee County hearing. And yes, at that hearing, the judge asked the question, does the state object to the modification? We didn't care which one of those 2 places that he lived. There was nothing substantively changing about it. And I said, we don't have an objection to where he lives, Judge. And that has been now turned into, oh, well, he never cared about whether or not he got a bond. He never cared about whether any bond conditions were being enforced. So, but just procedurally, that's how everything progressed in the order of the hearings and the locations of the hearings and the dates of the hearings. And then ultimately in 2022, in January of 2022, that was when we were told that there had been these violations of the bond conditions. And when we were told they were violations of the bond conditions, we asked SLED to get the materials. SLED actually turned the materials over to us March the 22nd of 2022 is when we got that information. March the 25th, the bond revocation motion was scheduled. And we knew we had one of 2 dates, either a Monday or a Friday during this term when we would have Judge Dennis there, who again, we had to find a First Circuit judge or a judge with jurisdiction in the First Circuit who had not recused himself. So that's why we ended up in front of Judge Dennis. For scheduling reasons, we couldn't get it done on the Monday of that term, so we did it on the Friday, and the Friday of that term was April the 8th of 2022.
And I'm curious, again, forgive me, the normal interaction with you and victims' families when they don't have an advocate, or again, in this case, an attorney who is representing them as an advocate. What is the normal procedure?
The normal procedure, we have victim advocates in our office. The normal procedure is for us to contact a victim advocate in our office and say, we need to speak to this victim about this because we need to explain what's going on. Or we need to speak to or we need to let the victim know this is scheduled or that is coming up. And we have multiple victim advocates in the Second Circuit. We have one in particular for Barnwell and Bamberg, but they can be supplemented by people from Aiken at any point in time. And for that matter, I don't have any question in my mind that if we had asked SLED's victim advocate, because these were all SLED cases, if we had asked SLED's victim advocate to notify the victims of anything, then they would have done that as well. But again, this wasn't one of those cases. And in fact, our concern was, ethically under 4.2, these are now represented persons. We're talking with somebody that we know to be represented. And so obviously my obligation ethically is not just to make sure I don't do it, but nobody that works for me does it either.
I'm curious on that to the degree, and not quibbling or trying to pick at this, but generally speaking, if you've dealt with South Carolina Victim Assistance Network before, Ms. Ford, is that standard that both sides of the victim and prosecutor side, they know not to and don't contact the families or the victims except through them? You follow my question?
Yeah, I do, and I don't know what is normal. I do know that in this particular case, Ms. Ford informed me when she said that she was representing them that all of the communications were to go through her. And I didn't have, and certainly I didn't have a problem with that, or I wasn't concerned about that at the time. you spoke earlier about representing victims in cases in the past, and we have that come up. It's not completely unusual, and out of professional courtesy, if nothing else, we're always going to let the attorney know, the victim has given us an email address. Can we copy you on the emails? And if the attorney goes, no, I'd rather you send the emails to me first so I can prep them for what they're going to get, then we're going to do that. We try to be as cooperative with all of the attorneys as we can. And so I don't know that it was unusual, because I've never dealt with Ms. Ford before that day in Dorchester County. I've never seen her. To the best of my knowledge, I'd never spoken to her before that day in Dorchester County. And despite how the end of the process of the plea throughout, all the way up until the week before, I thought we were getting along great. I mean, we had email communications back and forth. She had my cell number. She had my senior assistant solicitor's cell phone number. She could call us. We'd fire text messages back and forth to each other about what was happening. And there was a very specific time after March the 25th when we filed our motion. There was a very specific time whenever I got a call from Senator Hutto, and he said, hey, let's try to work this thing out instead of going forward with the plea. And I immediately sent an email and said, and in the email said, I got a call from Senator Hutto this morning. He wants to try to work something out. That was an email from me to Sarah Ford. And I said, if we work something out, I need to be able to meet with the victims pretty quickly, because I'm going to have to come up with the offer. I'm going to have to shape everything, make sure that we've got all of our bases covered. And at that point in time, the response that I got back was, will this offer encompass both cases? And that's another thing for clarity. At the time that Bowen Turner was charged in Bamberg, there was no other case pending against him. There had been a case. It was a family court case. It was out of Colleton. That's all I knew about it. It had been opened and it had been closed. And so that case had been opened and closed, and it was in family court. I've never prosecuted a case in family court in my life. Matter of fact, I've only been in family court probably 3 or 4 times that I know of. And so that case that was over in Colleton was not an issue as far as what we needed to get resolved. But early in that process, the week before all of this went on, I made it clear that the Stoller case was not a part of any plea agreement, that I did not feel that ethically I could go forward prosecuting a case with the evidentiary issues that I knew to exist without Dallas Stoller being available to testify. And I told Sarah Ford that as early as March the 30th. I made it clear that this is not the Stoller case. These are 2 separate things. And so when we met with Ms. Bess's mother, then and I talked to her about the plea. After I met with her, that's when I communicated the plea to defense counsel, the plea offer to the defense counsel. And it was the next day, it was April the 6th that I actually met with Mr. Stoller and his family, and it was by Zoom.
Senator Savin.
Want to thank Chairman Rankin for really asking you to consider having a conversation. For me, it was very illuminating, and I've got a very, I think, better understanding of procedurally how things flew, how things went. One question, in embracing all that's that's happening, particularly the dates. And for me, I don't need to have dates in front of me. When a lawyer appears before a tribunal, I accept what they tell me as an officer of the court. And that's what I've done with regard to what you've shared here today. But I'm curious, and it's a two-part question. As I understand it, on the Zoom call that you had with the Stoller family and others, the first question, I want to ask them both together. So the first question is, did you make the statement that I'm not going to waste the jurors' time or my time with a case that I know I can't win? And if in fact you did make that statement, do you have any regrets as to the impact of it, given what Mr. Stoller concluded and shared with us in his testimony today?
Senator, first, I do not specifically recall using those exact words. And I don't, and honestly, when Mr. Stoller was up here saying it, I think he said a case that I said that I wasn't going to waste anyone's time with a case that I wasn't going to win. And certainly, I don't recall that phrasing. But yes, I do absolutely regret any comment to him that made him feel that way. And in fact, one of my biggest regrets about this case as a whole is I think that it is the job of an attorney in pretty much any capacity to measure the responses and adjust, make sure that the expectations are measured for the people that you are working with. And in a perfect world, I would have loved to have been able to spend much more time with him and with the family. And I will make, just so there's no confusion, this April the 6th call, Zoom call, was strictly with the Stoller family and Ms. Ford. There weren't any other outsiders that were there. But I didn't do a good job of managing their expectations going along. And we ended up in a situation where, because of time constraints, I was trying to get everything put in ahead of time so that we could go and make this plea. And I did refer to this whenever I was explaining the plea to Ms. Bess, when I was explaining the plea to the Stoller family. I did tell them, we don't have Senate sheets. I don't know if this is going to be a plea. It's a bond revocation hearing. We know that. That's what we're going there for, is this bond revocation hearing, but it may turn into a plea. And I thought I was very clear about that was a possibility because the plea offer was out there. But obviously I would have liked for there to be a different lead up. And part of that, well, it doesn't matter what the excuse was. That's my responsibility.
That's all I have, Mr. Chairman. Thank you, sir.
Thank you.
Mr. Strong.
Thank you, Mr. Chairman. Mr. Miller, I think I've known you since you clerked for Judge Peoples.
Yes, sir.
And you're better than this. You've always been a tough prosecutor. I'm looking back through your file and I see where 2 sheriffs have written you letters, and that's after all this stuff has been public. Strom Thurman Jr., former solicitor, wrote a letter recommending you. But, you have created an issue that's an embarrassment to our judiciary and our court system. People, and you're better than this. You had a state senator representing somebody. You didn't do a good job communicating with the victims like you should. And there's obviously some temperament issues here. And I think we've talked about that before when you've run, you can have a little bit of a temper. And I think in your questions, you were asked about how you're going to address your temper.
Yes, sir.
And, I was going to ask you what you would do different. You've answered a lot of that. But I want to tell you, I'm mad at you for the way this thing has happened, because you've embarrassed our system. And I don't know whether you're going to get voted out of this today. I don't know whether you'll get elected judge. But I'll tell you this, if temperament is a big deal with this commission, and if you become a judge and you have this issue going down the road, I can tell you every single person sitting around here, we will vote you out the next time you come up.
Understood.
And this will be on the record the next time you come up.
Yes, sir.
Thank you, Mr. Chairman.
Chairman, I'm not quibbling or disagreeing at all with that, because again, I think he speaks for all of us in terms of how we view any brush with temperament
Yes,
and execution of the offices for which you are seeking. But I want to just harken back to the exchange on a very fine point on you said you, to Senator Sabb, would love to have been able to prosecute this case for the Stoller family. One of the comments in here, which we might get into in a little while if I hush, but effectively assails your bias against folks just like Mr. Turner, and that you would be so harsh on the defense that this is, to me, and that has been a kind of a theme that we've read about you. You've got incredible ballot box survey comments, but one of which, in fact, makes the point that, again, to Mr. Stoller, who is kind of in the fraternity of law enforcement and would get the best of the solicitors, whether it's his own or another areas, but within that fraternity. So your point about would love to have prosecuted, help me understand why you would have loved that. What does that mean?
Why I would have loved to have been able to prosecute the case? I felt like the Dallas Stoller case was the stronger of the two cases, that if I was going to go to trial in the case, that I would have tried the Dallas Stoller case first. As it relates to this belief that I am too harsh, I don't know what the word would be, or that I'm too aggressive towards defendants in some cases. All I can say about that is that I'm an advocate. I am an advocate for the state of South Carolina. When I am a prosecutor, in the decade before I was a prosecutor, I was an advocate for my criminal defense clients. I was an advocate for my civil clients. And I was an advocate, I was always a strong advocate for them. And so, yes, when I was talking to the Stollers and in addressing Senator Sabb's question, if I did, I told Mr. Stoller, look, I wanted to try this case. This is the case I wanted to try. And there were a lot of reasons for it. And I talked about some of the reasons with them that I would have preferred to try that case. But unfortunately, Ms. Stoller passed, and so I did not think that that was ethically doable anymore. I did not think that I could overcome the evidentiary issues that we would have without her testimony being available. I continue to feel that way. I know that my boss, Solicitor Weeks, is talked to the family about re-examining the case. I can't tell you what's going on with that because I don't know. But I wanted to get some level of closure for this family, for the Stoller family, and for the Best family. But I knew when I was talking to the Stoller family that if we couldn't go forward and there wasn't going to be, even if it was a guilty plea for concurrent time under the same considerations, if we were not going to, or with the same sentence, if there wasn't going to be that guilty plea, I knew that there was going to be, it was going to leave a wound. And I said before, I wasn't sure of the exact wording of what was said, but I do specifically recall the conversation between Mr. Stoller and it got escalated during the course of the meeting. And your point is well taken, Mr. Strong and Senator Rankin.
Mr. Miller, sometimes I have sat and a question to counsel to help the counsel arrive at his or her point. And I would be less than candid with you if I told you that I did not feel that same feeling just now after Senator Rankin had pitched you a softball. What I had hoped to hear in your response to that question of why you would have loved to prosecute him was because you were convinced that justice required prosecution of that man, but that you were unable to proceed because of the ethical considerations that you've clarified here. And so I would have liked to have heard more in terms of commitment to your ideas of pursuing justice because you had analyzed the case but had recognized the limitations under our professional rules of conduct. But that notwithstanding, I have another set of concerns that I'd like to talk to with you about because, again, we are charged to evaluate a candidate along the lines of the constitutional and statutory evaluative criteria. And the first relates to, well, let me start with the victim advocate in your office. I think you talked with Senator Reagan initially about that. Why was your victim advocate not reaching out to the decedent or her family immediately when you took possession of the case?
Because at that point in time, Sarah Ford was there. And I don't know, prior to that hearing, I assumed that it was our victim advocate in our victim advocate's office, or maybe it was the SLED victim advocate who was telling people, here's where the hearing was. We were actually talking to the SLED agent that was the lead agent on the case and explaining to them, hey, look, this is what's going on and this is what's happening. I don't know which office, whether it was our victim advocate or the other, but even in that situation, that victim advocate is an employee of our office and is under our control. Under the rule, they can't talk to somebody who's represented by counsel any more than I can. And
so when Ms. Ford communicated to you that she was going to represent the victim and the family, how was that communication made? Was that in writing?
It was verbally. I know that it was verbally. It may have been followed up by a letter. I don't recall whether or not that happened.
How did you notify the other people in your office that they were now restricted from communication with the victim because they were represented by counsel?
We have a very small office. So at that hearing that was in Dorchester County, it was myself and Michael Emmer, and I believe our victim advocate was there. If she wasn't there, then we just told her as soon as it was over with. But that's 3/4 of our office at that point in time. So it was not a very difficult thing to get the word out. Hey, these people are represented by an attorney. Everything has to go through the attorney.
And did you make that communication to people in your office?
Oh, yes, sir.
And you did that verbally or in writing?
Verbally, because we were all there.
Is it your ordinary practice to make notifications at that time only orally?
I would say yes, because it's not something that happens very frequently. So I believe, yes, I would say normally it's just done verbally.
I thought I heard in your testimony that there were several attempts or actual communications between yourself and Mrs. Ford. Is that accurate?
There were quite a few, yes, sir.
And those communications, they were to communicate times for hearings and what else?
Discussions about what was going on as far as plea offers. There was discussions, there was a discussion about the fact that Senator Hutto wanted to try to get the case resolved. I explained that I would be making a plea offer. She asked for me what was the plea offer going to be, what was I proposing. I sent that to her. She responded and said, can you explain why you were doing this? I responded to that. She said, okay, these are the people that want to meet. And so we did the same, actually, I think it was the same day we ended up meeting with them. There were numerous conversations that went back and forth about various things. The whole Lee County bond reconsideration thing, whenever I first got contacted about it, it was from defense counsel who said, hey, this is what we understand. Can he move back in with his parents? And I said, I don't know.
I'm sorry to interrupt, sir, but that issue is less pressing in my mind than the communication with respect to the plea offer. And if
Okay.
I understand the timeline correctly, you're telling us now under oath that you communicated to Ms. Ford as the attorney for the family that there would be a plea offer extended, and I presume that you actually included the contents of the offer, what the offer was.
Word for word.
And then subsequently explained your reasoning for that plea offer. And then you had the meeting, and if I have the dates right, that would have been the April 6th. Is that the Zoom call meeting?
It was April 4th that she got the offer. She inquired about what the rationale for the offer was. On April 5th, I sent the email saying, here's my rationale for the offer. She had indicated when she asked for the rationale for the offer that Ms. Bess wanted to talk. And so when I sent that to her, I said, just for clarity, I said, my first statement was, I'll talk to anybody who wants to talk. But just for clarity, when you say Ms. Bess, do you mean Chloe or do you mean her mom? She said, I mean her mom. And so we talked at 4 o'clock that afternoon.
And this was before the Zoom meeting with the Stoller family?
It was before the Zoom meeting with the Stoller family.
During the Zoom meeting with the Stoller family, did you communicate or discuss the plea offer?
I don't know if we discussed the plea offer itself, but the point of the call, the point of the discussion was to talk about why we couldn't go forward with the Stoller case. And because we couldn't go forward with that case, and it's another distinction that without much of a difference, but I think it's significant. I specifically said on that Zoom call that I would not be dismissing the case. I wouldn't be dismissing the indictment until after the plea on Friday. I said, I'm not going to dismiss it until after the plea on Friday because I didn't want there to be any argument that Mr. Stoller couldn't talk to the court because there wasn't an open case. It wasn't, I didn't want that to even be an issue. And so if we go back and look, we'll find out that, in fact, the plea was at 10 o'clock in the morning on April the 8th of 2022. And that case didn't get dismissed until that afternoon in Bamberg County because I left Orangeburg and I went to Bamberg, and that's whenever I dismissed the indictment. I did it specifically for that reason, and I told them that was the reason why I was doing it that way.
When at the bond revocation turned plea,
Yes, sir.
and forgive me, I read the transcript earlier and I don't recall exactly where the exchange was. There was some question about a continuance, that Ms. Ford had asked for a continuance to hold the matter over, and you objected to that. I think if I have it right, I think I recall page 7. Maybe that's the wrong page. That's all right. Nonetheless, the ultimate question is, and I ask because it's related to the question of temperament, of professional competence.
Do you want to continue?
Thank you.
Yeah. Knowing that Ms. Ford had communicated to you concerns, issues, a desire to not go forward with the case, given the gravity of the underlying crimes and the emotional resonance accompanying that, when the victims articulated a desire to not go forward with the plea, then you were given the opportunity by the judge to consent to a continuance. You didn't do that, and I'm curious why.
One of the things that I was very concerned about was the possibility of the bond revocation motion not being granted. If that bond didn't get revoked, then there was going to be an issue that we were going to have to deal with, going down the road as far as how to get this back before the court. And there was a point in time when there were concerns expressed about the fact that Senator Hutto had legislative protection. Early on in the case, there was some concerns about that. We were in a position where we had two things that we were fighting against. The first thing that we were fighting against was we could only make him come to court on Monday and Friday. Now, he never, and to his credit, he never said, I can't come to court. But we knew that we had to schedule our hearings either on a Monday or on a Friday. And also we had to schedule any hearings in front of a judge who wasn't a judge from the First Circuit. And so at that point, I felt like if we continued, I did not believe that it was a request for a continuance to, okay, we're going to continue all of this and we'll reschedule it for somewhere down the road and we'll come back later. I believe that what was being requested was, I want to continue this plea so we can argue about this bond revocation motion, which we had filed. We were completely ready to argue the motion, but the judge had already said the plea makes the motion moot. So I was in that moment, because I wasn't anticipating it at the time, but in that moment right there, I was thinking to myself, if we continue this, we're continuing everything. And we could end up down the road 4 or 6 months, however long. So I was trying to get a resolution to the case.
I'm struggling to reconcile that sentiment with the reality that you were in court on Friday, April 8th, but there was going to be a Monday, April 11th, and a Friday, April 15th, and a Monday, April 18th, and so on and so forth, where these things could have been accomplished. And I can appreciate the difficulty in scheduling, but clearly this case has taken you from Lee to Dorchester to Bamberg to Orangeburg.
Yes.
So I understand that. I guess the last question, and I see Mr. Rutherford has some questions that he wants to explore with you. I thought I heard Mr. Stoller say that at some point this case, after consideration by you, that it was passed to back to Solicitor David Pascoe for consideration of prosecution. Is that your understanding as well?
No, sir, that's not what happened. And I don't know that Mr. Stoller said that, or that.
Could be my faulty memory.
I certainly have a faulty memory as well sometimes, but no, what happened as far as the Stoller case goes, after it was dismissed, the Stoller family met with Solicitor Weeks, and they came in and talked to him. I wasn't present for the meeting or part of the meeting, but what I understood came out of the meeting was that Solicitor Weeks is reinvestigating or relooking at the case to make sure that nothing was missed. And that's all that I know about that. It's still pending review as far as I know.
Thank you, sir. Representative Rutherford, you still have questions?
Well, not a question, but a statement. I just disagree with the chairman's assessment of what happened on page 7 in the transcript. I don't believe that Mr. Miller said that he wanted to go on despite the objection of Mrs. Ford. I think he was simply saying that he was going to go on with the plea because the plea would trump the motion to revoke bond. And the judge had already said it was moot. And did he want to proceed despite the fact that Ms. Ford's motion was not filed timely? And you make mention of the fact that there were other Fridays and Mondays to come, but that is not in the record that Mr. Hutto or the judge would have been available on those Mondays and Fridays, because as he stated, you're talking about a judge outside of the First Circuit, and defendant who at that point ready to plead guilty with his lawyer and the state. So I don't agree with your assertion that he did anything except say that they were ready to proceed and take a guilty plea that day, because the court noted that the motion regarding the victims by Ms. Ford was not filed in a timely manner. So it's not a question to Mr. Miller, but just a disagreement as to how the chairman posits his opinion on what happened on the transcript on page 7. So.
Yes, sir. I appreciate that. Thankfully, I've gotten rather used to the fact that we don't always agree.
Yes, sir.
Mr. Saffron.
Chairman, I'm kind of trying to wrap my arms around something here. You just said that you were concerned about the revocation being granted as a reason to go forward with the plea. Am I correct on that?
No, sir, I was concerned that the bond revocation would not be
No, I
granted.
mean, you were concerned whether or not it would be granted.
Correct.
Okay, you thought that there was a risk or a real risk that it would not happen.
Right.
There.
And I also thought that there was a real risk that if the judge said, okay, we're continuing this matter, it just wouldn't get heard at all, which was one of the things that, the only thing that it appeared to me at the hearing that day, the only thing that it appeared to me was the object for Ms. Ford and for the people that were assembled was for Bowen Turner to walk out of that courtroom in handcuffs because his bond had been revoked or because he had pled and he had gotten some kind of incarcerative sentence or whatever it was going to be.
Well, let me ask you this. Could you blame them for having that object?
I don't blame them for having that
And
object.
the other question is this. I'm sitting here and I haven't done a criminal case in more years than I can count.
Right.
So if I'm saying something that proves to be foolish, I'll take responsibility for it.
Sure.
But, to kind of echo, what Mr. Stoller said, you got all this data showing that he was doing exactly the opposite of what he'd been told not to do, okay? So I guess my question is that where was your concern coming in terms of the revocation not getting granted? Because, I'm sitting here, you got a pile of stuff there that shows he's been, God knows, everywhere. And, I understand what Mr. Rutherford said, Representative Rutherford, about nobody was there laying eyeballs. Well, maybe not at that point, but now you got a stack of stuff from the company that basically has been monitoring him, saying that, he was clearly doing wrong.
Right.
And so, again, I'm a little concerned about where that comes from.
We had received information from the counselor for Bowen Turner, who had confirmed a statement that had been made that he had told Bowen Turner and Bowen Turner's father that he needed to be out. He needed to be out of the house, that he needed to go places, and he needed to not be locked up in his house, and that over the course of the times that he was not where he was supposed to be. And keep in mind, this was about the 5th time we had been told that, oh, there's some violation of his bond, when SLED had gone out and looked at it and not found anything. And so this happened in January, and we get all of these things where he's going all these places, and we say immediately, yes, let's go do this. And the response that we got back from Senator Hutto was, all of these places, he was always with one of his family members, and that was a part of his bond order, was that when he did leave the house, he couldn't leave the house without being in the presence of either his mother, his father, or his grandmother. He was always with somebody, an adult, whenever he was out. Every single place that he went, he was supervised. All of these locations were public places. His father was apparently prepared to testify that the reason that he went to Columbia was because they didn't want to run into somebody in Orangeburg that would get upset about him being out with his dad. There was a driving range that he went to, and according to what I was told, his dad was going to say that he was sitting at the driving range and watching Bowen Turner hit golf balls while he was talking to him. I felt like if you looked at all of the hours that Bowen Turner was on a GPS monitor, and you took all of the hours that he was not where he was supposed to be, it was going to be a minuscule percentage of time. It was a lot of places. It was a lot of hours, quite frankly. But I felt like someone with Brad Hutto's abilities in a courtroom could make an argument to a circuit court judge that a circuit court judge might go, yeah, I agree, he has violated, but he hasn't committed any new offenses. He's always been in the presence of a chaperone while all of this was going on. So what I'm going to do is I'm going to tighten down the conditions on him. And I felt like there was a reasonable possibility of that happening.
Well, was any of this shared with the Stollers or with, the other victim?
I did talk to, I believe that it was Miss Bess. I know that the conversation was had at one point, and it was just disregarded about the idea that there might be a way that the judge didn't grant the bond hearing or the bond revocation.
Was it a very in-depth discussion?
It was in depth, and that was. It was, why would a judge not grant it? And me saying, well, this is what I've been told. I got a response from Senator Hutto to my motion and laid out all of these things. And I said, this is what I was told.
Okay. And I mean, again, was that something that Ms. Ford, did you share it with her?
I don't know if I sent it directly to her, but I know that she was aware that that was what my concern was.
Well, and I think this kind of dovetails back with something I think Senator Sabb talked to you about, Mr. Strom talked to you about. I think basically what I've encountered in terms of trying to convey the legal realities or concerns to clients, and yeah, they're not technically your client, but they're your client in the sense that you're representing the interest of what's happened to somebody in their family from the state standpoint.
Yes.
I'm not saying there's a technical bond, but it's a practical matter. They're looking to you to take care of trying to do what's right because of what's happened to them. Okay, we agree
Right.
with that,
Yes.
okay? And I guess it goes right back again. If I'm listening to Mr. Stoller, he basically perceived a lot of indifference. He basically did not hear a heartfelt type of explanation about, this is terrible. I understand what has happened to you. I can't even begin to truly empathize because I can't, okay? Nobody can. But the point is, where was that recognition that these folks, they were grieving? I mean, they had a need to know, and it needed to be conveyed in a way more than what I'm hearing came across, not just from Mr. Stoller, but what you're telling us, that it just was indifferent, okay? And I think the last thing he said was, please, you know, my concern with the court system is it lets us down. Well, isn't this letting us down when somebody who is kind of their representative in the court system gives them the impression they don't care enough to even want to tell them, maybe in a way where he, as a seasoned law enforcement officer, would probably get it at some point. But when you basically at the beginning give the impression that I don't care, everything else tunes out. I mean, we know that as a practical matter. It all tunes out. Right. So, again, look, I'm not trying to pile on here, but it's a real issue. And I guess the concern is that if you, as wearing the solicitor's hat, didn't seem to care enough about the human aspect of this, where are you as a judge who's also supposed to recognize the human aspect of this? You understand why there's a concern?
I absolutely understand why there is a concern. And I would say no one, including Mr. Stoller, knew the way that I was agonizing over the decision. So as far as presentation, as far as the appearance to them, that is reality. What is the appearance to them is the reality of the situation. But I do take some level of objection to the term lackadaisical, because that's not what it was. It wasn't a lack of interest.
Well, look, there's a difference between lackadaisical and indifferent, but you know what? The effect's the same thing.
I understand. And I understand how it came across in this situation.
Well, and I think what you just echoed is what we heard here the other day from Justice Kittredge, is that the only way that there's going to be confidence from a public standpoint, much less individuals who you're dealing with who actually have a stake in this whole thing, is for there to be something that is the exact opposite of indifference. It has to be, we're here to serve you as the public's court, the public's prosecutor. And when you have somebody walking away, again, who's part of the system himself and who understands how, quote, things work, but having him feel like that and say, they just let us down. I mean, there's really no room for that, is there?
There's not.
Okay. Thank you.
Ms. Blackley, I'm afraid, was first up.
Mr. Miller, are you familiar with the Victims' Bill of Rights?
I am.
So you know all of them?
I believe so.
One that just shoots right at my mind, and I think you heard me earlier, I am a former victims advocate, and I'm a former solicitor victims advocate, all the way from local to state house. I'm the former crime victims ombudsman. So after hearing my colleague talk with you in regards to the indifference, what comes to mind is, one of the rights is to be treated with dignity and respect.
Yes, ma'am.
And that's just bringing up red flags by mine, because outside of murder, a very high crime of high emotion would be sexual assault. And so there's a way in which we have to work with our crime victims.
Yes.
On any cases, and and I, again, worked in a solicitor's office, and I worked with my solicitors, but I also would challenge them if I felt like they were violating any victim's rights. And it's concerning, and I hope that what has been stated here today that you take in, because if you're in the black robe and you are presiding over court and there's an injustice going on with the presentation of a case and the violations of rights of victims are occurring, that person in that black robe will take charge of that, make sure that happen. And I want to just make sure you understand that if you were to ascend to that bench, that would be expected of you. And I will second what Mr. Strom stated. If that doesn't happen and you're back here, that will be a huge problem, and it will be my biggest problem. Yes, so I want you to take that wholeheartedly into consideration.
Absolutely.
Thank you.
Thank you, ma'am. Senator Sapp? Okay. Do any other members of the commission have anything to ask at this stage about the complaint? It's plural, I apologize. Okay, with that in mind, let's take a brief recess. We've been going about another hour or so, and so we'll reconvene in about 5 minutes or so. Thank you. Ladies and gentlemen, we will go back on the record and continue with our screening of Mr. David Miller, who is an applicant for seat 2, 2nd Judicial Circuit Court seat. We have dealt with the complaints in this matter. At this point, it may be a bit of a non sequitur, but would welcome any brief opening remarks you may have as to the balance of your candidacy. And if you want to forego that, we can go straight to questions from staff.
I would appreciate the opportunity to go straight forward.
Okay. Also, thank you for reminding me, Senator. If you'd like to introduce your wife to the panel, we'd be happy to meet her.
My guest and coworker, not my wife.
All right. I like when I do that.
Sorry about that.
Sorry, no pressure.
This is Senior Assistant Solicitor Lee Staggs from the 2nd Judicial Circuit. She is one of my coworkers and friends, and obviously somebody I lean on a lot for a lot of help. So
I have tried all day to intentionally not infer a relationship, but I was the power of suggestion had gotten me, so I apologize and certainly didn't mean any offense. Okay, at this point then I would recognize Mr. Triplett for some questions.
Good evening, Mr. Miller. How are you?
I am well, thank you, sir.
I know for the record that based on the testimony contained in the candidate's PDQ, which has been included in the record with the candidate's consent, David Miller meets the constitutional and statutory requirements for this position regarding age, residence, and years of service. Mr. Miller, why do you want to be a circuit court judge?
I want to be a circuit court judge because I believe it's the next step in my legal career. I want to help. I want to be somebody who helps the system. We talked about that a little bit here earlier today about the necessity for people having confidence in the system and it doing the right thing. And I think I have the experience to make those kinds of decisions and to do the right thing and have people understand that I'm doing the right thing for the right reasons and to give them that confidence in the system.
Thank you. Mr. Miller, how do you feel your legal and professional experience thus far renders you qualified and will assist you to be an effective circuit court judge?
Well, as I mentioned before, I do have a bit of private practice experience. For almost a decade, I was in private practice. I was a kind of a do-everything attorney whenever I was in Aiken. You kind of had to be, but I did criminal defense, did not represent insurance companies, but represented defendants and plaintiffs in civil cases. Had a lot of experience and good experience there. Prior to that, I was a law clerk for Rodney Peoples, which anybody who knew Judge Peoples will tell you gave me a great deal of civil practice experience in a very short period of time. And then going to the solicitor's office and working my way up there. I've been on both sides of the courtroom in civil and in criminal cases, and I understand some of the difficulties that the people that are out there are having to deal with. And I think that that's one of my better attributes as far as my experience. It is being understanding of what lawyers have to do sometimes to be in 3 counties at once, or dealing with difficult clients and those types of things.
Mr. Miller, the commission received 295 ballot box surveys regarding you with 64 additional comments, 50 of which were complimentary. The ballot box survey, for example, contained the following positive comments. David is very knowledgeable of the law and can explain his reasoning for his decisions. He is stern, but in a kind way. He would be a terrific judge. Mr. Miller is an excellent candidate. I've dealt with him as both a prosecutor and a defense attorney and found him to be fair, impartial, understanding, and amicable. He possesses the character we desire in jurists. And lastly, David Miller is one of the most qualified candidates for the bench I can think of. His years of service to the practice of law have been a credit to South Carolinians. His breadth of, his breadth of knowledge is truly extraordinary. In addition, he's a loyal and dependable person that never hesitates to help fellow lawyers or friends in need. He's a very kind person who would be an excellent judge. He would be fair and courteous to all those appearing before him, despite which side of the case they would be representing. 14 of the written comments express concerns. Several comments express concerns with your demeanor and temperament in the courtroom. What response would you offer to these concerns?
I am aware that I am, I'm certainly passionate about the positions that I take in the courtroom. I think that it's pretty much it is a testament to the fact that I have the friends that I do because of the fact that I realize that. And very often, two things, very often, you know, make sure that I haven't offended somebody, make sure that by going to them and saying, you know, hey, look, that was a little bit more than I anticipated it being. And also, you know, making sure that that whatever goes on in the courtroom stays in the courtroom as far as that goes, not letting it affect my relationships with people as it relates to other clients and those types of things. But I do think it's fair to point out in that regard that there are times whenever, because of my position as the end of the line before you get to the solicitor making decisions, that there's going to be disagreements about cases. There's going to be disagreements about what needs to be done. And I know that there are a lot of times when I'm really trying hard to find some kind of reasonable compromise and working to try to find some way to help a lawyer with their client, or to help a victim get some kind of relief that maybe the circumstances don't necessarily normally look like that. And sometimes you just got to draw the line in the sand, and that can be interpreted poorly. So I try to make sure that that doesn't carry on. Obviously, though, on the bench, you're not an advocate. You're not an advocate for either side. And so that is one of the reasons why I feel like I would have a better control over you know, anything that was going on in front of me. I mean, I'm not advocating for either side in that position, whereas as a deputy solicitor, I have to advocate for the state.
There were 31 positive comments regarding your ethical fitness, character, and reputation, but 7 comments expressed concerns that you tend to show favoritism or bias. What response would you offer to those concerns?
Well, again, it goes back to being in a criminal courtroom as a deputy solicitor. I'm the one who sets the order that things get done in. And if there's that attorney who's got to be in multiple places at one time and they come into the courtroom, they're going to the front of the line. If there is a situation where there might be somebody who has a hearing that they need to get to, or if there's somebody who needs to talk to the judge, or even, you know, attorneys that come in and they need to try to get in a minor settlement hearing, something along those lines that doesn't have to do with us. My position's always been, and I think it's pretty well uniform throughout the state, my position has always been, you've got to be there anyway. Get those people in and get those people out. And to somebody that doesn't regularly work with us. I can see how that would be perceived as favoritism towards private attorneys. But one of the things that we're very, very proud of, and we've said over and over again, is we don't give different deals to private lawyers than we do to public defenders. We don't give different deals to lawyer legislators than we do to non-lawyer legislators, or non-legislator lawyers, I'm sorry. There's not, the offer is based on your client and the crime. That is one of the things that we take pride in. And it's, sometimes there might be differences in the cases that, aren't very obvious to the outside, but there's not any kind of intentional favoritism. And in fact, it's very much discouraged. Any kind of favoritism or bias towards or giving better deals or anything like that for private attorneys in general is just completely frowned upon by our office.
There were 28 positive comments regarding your professional and academic ability and experience, but one comment expressed concerns with your ability to understand complicated matters. How would you respond to that concern?
I really don't know how to respond to that without knowing what the basis for the comment was. We've dealt with some pretty complicated stuff, both from the prosecution and defense side, handled capital litigation. I've been involved in some pretty complex civil litigation in the past. I was very young at the time, so that not, as the lead counsel, but I think that I can figure it out and certainly would.
Thank you, Mr. Miller. I would note that the Midland Citizens Committee reported that Mr. Miller is well qualified in the evaluative criteria of professional and academic ability, character, reputation, experience, and judicial temperament, and qualified in the remaining evaluative criteria of constitutional qualifications, ethical fitness, physical health, and mental stability. The Midland Citizens Committee noted that Mr. Miller is very qualified and with his past experience will be an asset to the judiciary. There are a few additional items to put on the record. Mr. Miller, are you aware that as a judicial candidate, you're bound by the Code of Judicial Conduct as found in Rule 501 of the South Carolina Appellate Court Rules?
I am.
Since submitting your letter of intent, have you contacted any members of the commission about your candidacy?
No.
Since submitting your letter of intent, have you sought or received the pledge of any legislator either prior to this date or pending the outcome of your screening?
I have not.
Are you familiar with Section 2-19-70, including the limitation on contacting members of the General Assembly regarding your screening?
I am.
Have you asked any third parties to contact members of the General Assembly on your behalf, or are you aware of anyone attempting to intervene in the process on your behalf?
I have not.
Have you reviewed and do you understand the Commission's guideline on pledging in South Carolina Code Section 2-19-70E?
I do.
Mr. Chairman, I would note for the record that any concerns raised during the investigation by staff regarding this candidate were incorporated into the questioning of the candidate today. Mr. Chairman, I have no further questions.
Thank you, sir. Do any members of the commission have comments or questions for Mr. Miller? Senator Sapp.
Thank you, Mr. Chairman. Mr. Miller, I'm sort of reminded of how the practice of law was 36 years ago when I first started practicing, and it'd be nothing for the person as a lawyer to be chastised by the judge in public, to be challenged in a way that some of us probably thought was a little over the top in public, but yet we had to stand there as a professional, receive the information, and respond to the information appropriately. And so I just want to say that I thought that the questions posited to you were fair. They were assertive, but the manner in which you handled them reminded me of the old days when I was in court and judges challenged me in various ways. And I think we grow from all of our experiences. And so I wanted to compliment you in the manner in which you responded to what you were confronted with here today.
Thank you, sir.
And also wanted to express my appreciation for your service to our country and the Marine Corps. And so it's clear to me when I look holistically at your record, your contributions to our way of living, your contributions to our profession, in my mind, have been impactful in more of a positive way than in a negative way. Although when we find ourselves in the middle of circumstances like this, I mean, it's telling and it's important and it's substantial, but it's not the entire picture. And so, for me, I like to look at things holistically. And so that's kind of how I approach and I evaluate things. I like to listen to the complainant. I like to listen to the person who gives the responses, and then ultimately puts me in a position where I can engage in self-evaluation based upon what I call all the evidence, the totality of the circumstances and all of that. And one of the things that I'm going to ask the chairman and this body to consider is I'd love to see the emails that you sent and the emails that were sent to you. So one of the things that I'm going to ask is for both of you lawyers, if the commission agrees with me, to submit your emails so that I could look at them and evaluate them in the context of the communications. Would you have any objection to that?
I would not.
So, Mr. Chairman, at the appropriate time, I would ask that we ask the other young lady, if she doesn't mind, who was kind enough to come and testify before us today, to also share the email communication that's been testified to.
I'll second that. At the appropriate time.
I think it's certainly something we should consider as a commission. I think it would be appropriate to have a briefing from staff on the attendant legal issues with that, but I think we could come to some resolution rather quickly. Any further questions, senators have?
No, and I just wanted to thank him and thank everybody else for participating in the process.
Chairman Ring.
Thank you, and again, a very unique experience for us. We don't often have complaints that go to the level as this one. Again, there's always an aggrieved party that we encounter in these complaints, and our job is to decide whether the complaint rises to the level of the non-evaluative criteria, which can be distilled basically in fairness, due process, and I'm going to say the golden rule. And in this case, one of, I think you have prosecuted or handled, did I read 5,000?
More than 5,000 that were cases assigned to me. That doesn't count the ones that I was assisting on.
And I will identify the source later, but perhaps in the, Strom Thurmond Jr., who was both solicitor and the U.S. attorney?
Yes, sir.
Said that you are the only one who has both prosecuted and defended capital murder cases to verdict. Is that correct?
It was the defense of the capital case was actually in a post-conviction setting. However, yes, I have prosecuted and defended. I've been on both sides, I'll say it that way, not prosecuted and defended, but prosecuted and provided a defense in the PCR stages of the David Mark Hill case.
I don't know you, and I think I said that from the outset, and rarely do we know the applicants to the degree that those who write on their behalfs do. And I can't help but call attention to those who know you best, Strom Thurmond. Or do we, what do y'all call him? Is it Strom, Pete?
Strom.
Strom. Anyway, who, like a candidate earlier today, James Smith, who is running for a circuit court position, said of David Wilkins, he doesn't suffer fools lightly, and he doesn't pay compliments unless warranted. I would think both your former solicitor, both sheriffs would probably, if they were sitting here and if this story gets fair and balanced reporting, regardless of the outcome, would say, as I think you have, you had a bad exchange with one of the over 5,000 victims and or cases that you prosecuted, and that you regret. I'm not putting words in your mouth, but I think I've heard that. But you have been awarded countless things by countless prosecutorial groups, and so again, I'm not defending you, but your friends in the profession certainly have. That's not dispositive necessarily, but I don't want you to leave here thinking that, what in the world are you doing here? And for the world to believe, hey, this guy doesn't know anything about the prosecution of one part of the circuit court's docket, and that is criminal law, which we more and more find that is more in demand than the civil. Yes. So anyway, that is not a defense of you necessarily, other than you've got great attributes based on people that know you better than I'll ever know you. And for that, I would suggest to you that is a good thing for you. I don't know whether we're finished, but I do want to invite you to tell us what you've learned from this. Again, regardless of the outcome of this vote, whether you're found qualified, whether you're nominated, what as a life lesson do you take from this? And again, if you were fortunate enough to ascend to a position of holding others accountable and judging others, what is your takeaway from this?
I think that the first takeaway is sometimes it is best to slow down, to step back and try to give things some air, try to give them some room to breathe, so that you're not always going to agree. Not everybody's not always going to agree, but if I had anything to do over again with this, it would be taking more time to try to make, well, specifically Mr. Stoller and the Stoller family understand the reasons that I didn't feel like I could go forward with that case. It turned out not to be a good conversation. And frankly, I reacted poorly to it. But that is one of those things that sometimes experience is the best teacher. I would say that confronted with a similar situation in the future, I would handle it differently. I would be more active and more insistent. And this is not an excuse. And I want to make sure that I'm clear about that. But the majority of the time that this case was pending was during COVID. And there was so much uncertainty about how we were going to have court, where we were going to have court, how we were supposed to let victims talk and address and that sort of thing. And so, the first time that that I specifically reached out to Ms. Ford about talking with Dallas Stoller, I was just struck because I was going through the emails the other day about, I think it was in April or maybe May of 2020. And we were kind of like, well, we don't know how long this is going to last, but whenever it gets back to normal again, we had no concept that it was going to be 2 years before it was back to normal. And you know, I think about that, and I think about all of the things that I didn't know and all of the things that I wish I had known at the time. But at the end of the day, I just need to make sure that I am more cognizant when I'm dealing with, particularly these types of cases. As Ms. Blackley said, these are the types of cases that understandably are going to have people really, really upset. And I think that slowing down the process so there was more time for the information to be absorbed would have been a lot of help in the case. And also making sure that information was getting to them.
Thank you, sir. Any other questions?
I would ask, though, before we adjourn the hearing, that we ask Ms. Ford whether or not she's got any objections to turning over the emails that pertain to the subject matter of this.
Sure, I don't see a problem with that. Ms. Ford, if you'd come forward just so that we can make sure you have an opportunity to have your voice recorded. You are still under oath, and the question is whether or not you have any objection to the entry of emails between yourself, Mr. Miller, having that entered into the record.
I have no objection to that. I have every email that we've ever exchanged present here with me today. I would like to go through, because there is an unnamed victim in which I have represented that was a part of the entire Bowen Turner universe, so to speak, and want to make sure that her confidential information is not in those emails. So if you all would give me the opportunity to go through that, I would appreciate that. I would also like the opportunity, and would certainly request, a number of things were brought up here today that I would certainly like to respond to, and I think
Yes,
would be
ma'am.
more full. And maybe this is not the venue, but if
It's not. I appreciate that sentiment. The question, though, was simply whether or not you would have any objection to entry of those emails. I'm hearing yes, pursuant to, provided that you have the opportunity to redact that relevant information.
yes, sir, provided that I have the opportunity to go through with that confidential information.
The
And
other question that I need to ask, though, is to the extent there is any attorney-client privileged matters in that, whether or not you would waive that privilege, or if you can waive.
I don't have the ability to waive that privilege. I would have to discuss that with my clients, of course.
Okay, if you would please take the opportunity to do that now-ish. We are going to adjourn this hearing. We're going to go into an executive session for a legal briefing.
Mr. Chair. Before you do that, can I ask her one question? She presented first. We then heard from Mr. Stoller. We then heard from Mr. Miller. And quite frankly, there's just something I've been sitting over here trying to figure out this entire time. And if I'm not proper in doing that now, just tell me. But
I certainly understand, because I carry a lot of those questions as well with me, Senator Talley. Unfortunately, I'm advisedly that our rules don't allow for that. It's a one-shot presentation. The commission would have some options for requesting additional information. We can talk about that.
is it proper for me to state that publicly, what my concern is, and they can address it at a later time, or is that?
I don't see any problem with that, provided it doesn't take too terribly long, given the late hour.
It won't take long at all. And I'll address this to the commission, and certainly don't mind others hearing. One of my big concerns about what I was hearing as these complaints were presented was a lack of communication, and trying to understand where that was coming from. If I understood Mr. Stoller's testimony correctly, he said he did not learn of a plea offer until he was in the courtroom and it was put on the record. We then heard from Mr. Miller that he had a conversation with Ms. Ford in which they discussed the plea offer, I realized with another family, if I got the dates right, about 4 days before the plea hearing. I would like clarification on who know what when. I get the whole temperament discussion that we've had, and that's something this commission can consider. maybe these emails, which I think are proper, vet that out some. But I heard Mr. Stoller loud and clear when he said he didn't know there was a plea offer that had been made until he got in the courtroom. There's been other testimony about when that was actually disclosed.
I think I understand your concern, Senator. Ms. Ford, thank you for your assistance. Given that Mr. Miller has not left and we have not concluded this screening process, I think if Mr. Miller would come back to the podium, Senator Talley, you would have an opportunity to ask him whatever it is that you want to ask.
I don't have any question for him. I heard what he said. He said, I believe, April 4th.
April 4th was the email with the completed, this is what we intend to offer.
Right. And then there was a Zoom call.
April
Or a
5th
meeting.
at 4 o'clock.
Right. And all of that predated the Zoom call with Mr. Stoller.
Mr. Stoller, the Zoom call with the Stollers was April 6th.
Okay. All right. That's what I thought I heard.
Great. Thank you, Mr. Miller. Appreciate your time being here. Thank you for your service to our country and our state. This will conclude this portion of our screening process. I do want to take the opportunity to remind you that pursuant to the Commission's evaluative criteria, the Commission expects candidates to follow the spirit as well as the letter of the ethics laws, and we will view violations or the appearance of impropriety as serious and potentially deserving of heavyweight in screening deliberations. On that note, and as you know, the record will remain open until the formal release of the report of qualifications, and you may be called back at such time if the need arises. I thank you for offering for service on the bench, and I wish you all the best. Again, apologies for the mix-up in identification of the relationship. Fortunately, I'm still learning as well. So wish you a great night.
Thank you very much, sir.
Thank you.
Thank you all.
On motion of Representative Jordan, seconded by Senator Rankin, the pending question is going into executive session. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. We will go into executive session at this point for a legal briefing. We kindly ask that everyone who is not a lawyer on the commission or a member of the commission to step out.